Felipe, the floor is yours to start with our first topic, the registration of advertising slogans as trademarks. Please.
Well, thank you, Elisabeth. Good morning, good afternoon, good evening to everyone who is listening to us. I also thank IDS for the invitation. It will be a pleasure here to be trying to share some of the experiences about these new topics. Before I get into the proper topic, I would just like to announce to everybody that whoever has questions, please send them on the chat because we will be checking the chat while we speak. And if possible, we will try to address all questions and observations on the different topics as we speak. So the idea here is to do something very dynamic. It will be almost like a conversation between Rafael and I. And so please, if you have any questions or any observations, please join us in this conversation as well. So as Elisabeth already introduced, the first new recent update of the Brazilian Trademark Office is the examination of slogans. This is not really a completely recent update anymore because the new guidelines of the Trademark Office have been in place for over a year now, since end of November of last year. But it's still a very important topic, and it's a very positive development in the Trademark Office's understanding. So we thought it was worth to bring it to your knowledge. So slogans in Brazil, according to the Brazilian IP law, a sign or expression used solely as means of advertising cannot be registered as a trademark. So traditionally, the Brazilian Trademark Office has applied a very strict understanding of that provision of the law and used to reject in practical terms basically any signs that look like a advertising expression or like a slogan. I mean, to be honest, if the sign would have more than 3 words, it would very likely be rejected by the Trademark Office. So it was a very strict understanding. With the new guidelines implemented since the end of last year, the Trademark Office is now adopting a much more flexible understanding and interpretation of the law. So basically, what the new guidelines are stating is that if the slogan can also be perceived as a source identifier as a trademark, it may now be registered in Brazil, and this is a very good and helpful development for the users of the trademark system in Brazil. So now the BPTO will also consider the inherent distinctiveness of the signs, like it already does with usual products and services trademarks. So in the new guidelines, the Trademark Office has now clarified that the sign will only be rejected based on item 7 of Article 124 of the IP law if it meets both of the following, and here I highlight cumulative conditions. And these conditions are that it serves an advertising function and it is incapable of serving a distinctive function. So in practical terms, in other words, this means that if the sign in question contains any element that is capable of providing the sign with distinctiveness, it will be in principle allowed by the Trademark Office. And here in the guidelines, they even cite some very interesting examples of signs that will be registrable and not registrable according to the new guidelines. And I will mention just a few of them to exemplify the new guidelines of the BPTO. So the first one is the sign, the best shoe in Brazil for shoes. And this is not registrable because it's commonly used in the advertising industry. It's basically describing a characteristic of that shoe. It's a laudatory expression, so it doesn't change much from the previous practice. Same understanding for another example cited by the BPTO here. Here it is cheap every day. So it cannot be reasonable because it describes the conditions that the services are offered. But here's where it gets interesting. So the next two examples are examples that had been previously rejected by the BPTO based on the prohibition of registration of slogans, but that now are expressly cited in the new guidelines as registrable signs. The first one is Panamericano, all for you, for bank services. Panamericano is a bank trademark, is a traditional bank in Brazil. And this is a registrable sign according to the new guidelines because the distinctive element Panamericano is capable of conferring distinctiveness to the sign. So this is a major change in the understanding of the Brazilian trademark office. The next example is I Can't Believe It's Yogurt, the famous frozen yogurt trademark, which had also had been previously registered, but under appeal and after a lot of arguments before the BPTO, that is now clarified as a registrable sign because even though it's an expression that may be interpreted as a laudatory or recommendation of the offered goods, it is an unusual structure that contributes to consumers recognizing it as a sign capable of identifying and distinguishing the product. So basically, it's an inherently distinctive sign. As we can see, Trademark Office has moved from a very restrictive interpretation of the law to a much more flexible one. And of course, this new approach will open, many new opportunities for the users of the trademark system in Brazil to protect other elements of their marketing campaigns, of their strategic advertising means, and other signs that traditionally were not able to be protected in Brazil. So it's in general a very positive new understanding adopted by the Trademark Office, and one that is worth noting and worth advertising for the users of the trademark system in Brazil. So now, before we move to the next topic, I ask if Rafael has anything to complement. Do you have any further comments, additional observations to the topic, Rafael? If not, we just move to the new topic.
Sure. Thank you, Felipe, and good morning, good afternoon, good evening to everyone. Thank you so much, IDS, for this invitation to speak on these latest developments. And Felipe, I totally agree with you, although this might not be one of the most recent changes at BPTO practice. These last few months allowed us to confirm that the office has effectively changed its standards when reviewing marks, which are also composed by slogans, and has been quite lenient on the standards as long as it's possible to detect some sort of distinctiveness on the trademark. And another aspect that I think is quite interesting, particularly for those practicing in Europe, is that the BPTO does not intend, at least for now, to review the actual content of the claim itself that is being made in the slogan, whether it's supported by any sort of objective elements or based on advertisement law, consumer law, and particularly whether or not it's when it comes to sustainability, for instance, if it's true or not. And that's a different approach from what we've seen that has been discussed in Europe with the Green Claim Directive. So at least for now, this is not an issue here in Brazil. Let's see how it develops. But it's certainly a new possibility for trademark holders that are developing their own taglines and slogans.
Perfect. Yeah, many things. It's indeed a very positive development, and hopefully it will stay that way. And I think it was something that used to be discussed a lot in the Brazilian IP associations. It was a request from the users for many years, and that has been addressed by the trademark office, and it's very it's very positive, and we're already seeing concrete results deriving from this new guideline.
And now moving forward to the next topic, which is the priority processing of trademarks, which might be of particular interest to trademark applicants in Brazil, given the latest backlog at the office. So Felipe, what's there with the BPTO on that aspect?
Well, again, a topic that has been asked for many years from trademark practitioners here. We're also a little bit envy because patent practitioners already enjoyed some priority processing at the Patent and Trademark Office. So it was not fair that we would not have some conditions also for prioritizing trademark applications. So this is, again, I'm being repetitive, but again, a very positive development and something that might be very useful in very concrete cases. To provide a general overview of the topic, well, the main objective of this topic is to prioritize the examination of trademark applications in Brazil. It applies both to national applications and registrations and Brazilian designations filed through the Madrid system. So it covers pretty much every trademark being applied for in Brazil. The goal of the trademark office is to examine those prioritized cases in up to 2 months. So as you can see, it's very fast. And I think even in international standards, so 2 months is a very fast processing of the case. The project was already implemented. It started on August 7th of this year. So we are now completing almost 2 months of this pilot project. And later on, I will talk a little bit of the statistics. Uh, how to apply for the prioritization of the trademark application is basically filling up a form, and the guidelines of the trademark office basically bring two modalities of acceleration of examination. The first one is the priority defined by law, and so this is for elderly people, people with serious diseases, disabled persons, and companies that fall under a government innovation program called Inova Simples. So those are pretty much straightforward cases already defined in the law. Where it gets interesting for trademark users in Brazil is the second modality, which is priorities based on strategic objectives and public policies. So, and for this purpose, the applicant must fall into one of the following categories. I will briefly mention them here to you. The first category is the prior user rights. So it's for those cases where the opponent proceeded against a trademark application in Brazil based on prior use of the mark, as established in paragraph first of Article 129 of the Brazilian IP law, which is an exception of our law, which is usually a registration-based system, but that foresees this exception of the prior user rights. And in practice, how the trademark office will do in those cases is that when the prioritization is requested, it will basically it will look at the evidence of the prior use of the mark in Brazil, and if it sees that the trademark is indeed in use in Brazil, it will examine first the application filed by the prior user in Brazil. It will grant that application in an expedited basis, and based on that granted registration, will then reject the opposed application. So this is, for trademark users in Brazil, this is very, very important development and something that can be used in very practical cases. The second modality is those who depend on the granting of trademark registration for the release of public financial resources. Translating that is basically companies or people applying for government loans that depend on a valid trademark registration. I mean, the project is based on a trademark that needs to be registered at the trademark office. So, this is not so usual, but we've had a few cases before dealing with that aspect. So it's also something that can be used in some conditions. The third modality is if the party is involved in legal proceedings, either at the federal or at the state level, involving that particular trademarks. Here, there's an exception. No writ of mandamus are encompassed by this modality, but this is just a minor exception. And here, it's just important to note that this is a very similar modality as one already applied for patent applications. But here, the interesting thing is that the case needs to be in court already. So only trademarks which are already subject of court action will be able to be prioritized, will be examined in those 2 months. But again, this is another very important modality, because if you have an infringement occurring in the market already, you might be able to expedite the examination by the trademark office, and this might provide a lot of clarity for the resolution of the litigation. The other modality is as those who have a product or service resulting from a patent which was prioritized by the BPTO. So this is interesting too. So if you have a patent that was prioritized by the local trademark office, by the local patent and trademark office, you might request the prioritization as well. So this is something good. Here, there's a limitation of only one trademark per accelerated patent. So if you had one accelerated patent, you'll be able to get one accelerated trademark. There's this limitation, but still, something that can be very useful as well. Another modality is legal entities that are considered scientific, technological, and or innovation institutions as defined by law. So this is very specific. Also, another modality is individuals that were mentored by the patent and trademark office under technical cooperation agreement. So this again specific. And the last one, those applications that are covered by a situation of public interest or national emergency declared by the federal executive branch. So this is basically for trademarks which involve some sort of public interest around them. So for the priorities based on strategic objectives and public policies, there will be a limitation of 1,200 cases at the beginning. For priorities based on the law, there's no limitation. So if the person proves that it's over 65 years old, it may just get, or that it has a serious disease, it will be, the trademark application will be expedited by the trademark office. Here, important remark is that each applicant will be able to prioritize only up to 3 trademarks based on this pilot project. So we have to be careful not to be starting to claim many prioritizations. We have to really select which are the important cases. And because I think the trademark office is implementing this project on a pilot basis, so it wants to see whether we'll really pick up or not. So this is an important aspect. In terms of official fees, for the priorities defined by law, there are no fees involved. For priorities based on strategic objectives, the fee is of 890 Brazilian reais, which is less than $200. So the fees are probably not going to be a very major aspect here, especially for foreign applicants. A little bit about the statistics, which is interesting. The statistics that are available until now are only of the first month. So the project started on August 7th, and we have the statistics available up to August 31st. So in let's say the first 23 weeks of the project, we had 222 cases of prioritizations based on the law. So 84% of them are elderly people. So this was already somehow expected. And 18 cases based on priorities of strategic objectives and public policies. I was a bit surprised with the number. I would expect higher numbers. So 18 cases in the first 3 weeks. It's very few in my view. Again, we don't have the numbers for September, so they might have picked up because August was exactly when the project started. So I think as it picks up, probably numbers will grow. But out of the 18 cases that were prioritized on this modality, 11 of them were for ongoing infringement court actions, which is also somehow expected. 4 cases based on oppositions, which were based on prior user rights, and 3 cases of legal entities that are considered scientific, technological, and innovation institutions. Only 1 case has been examined so far based on prior user rights, so we're still yet to see the decisions of the trademark office. But again, it's very handy, especially for trademark owners which are facing an infringement in Brazil or that are using a trademark in the Brazilian market without a registration, and somebody is trying to register their trademark. This acceleration might be a very interesting tool to fight against infringements. Again, other modalities such as public financing is also important, technological entities, but I think especially these two infringement cases and prior user rights, it's something that we should definitely keep in mind when we develop trademark strategies in Brazil. I think that's basically what I wanted to talk about. Rafael, I don't know if you have any further comments on the topic.
I agree, Felipe, that this is a very important tool for trademark applicants in Brazil, particularly when you take into account that backlog is unfortunately increasing. And for context, we have in Brazil each year almost 500,000 trademark applications being filed. So when you're able to prioritize a trademark application and have it decided within perhaps 2 months, this will be certainly very useful. But frankly, I'm not so surprised with the low numbers on this because of the limitations that the office have imposed on the instance where you can prioritize a trademark, aside from the regular legal possibilities. And we hope that with that, the BPTO might be convinced that it can open to new situations, such as a cease and desist letter, for instance, instead of waiting for an actual court action being filed, so that the parties could perhaps come up with an agreement before they had to resort to court. So let's see what happens there.
Perfect. So the let's say simplified opposition system that is being introduced by the trademark office, or I prefer to call it pro forma opposition system. It's basically another possibility for trademark users of filing oppositions against applications based on a senior trademark. So based specifically on Article 124, item 19 of the Brazilian IP law. And basically, it's a pre-approved proceeding. The opponents will need to file a form provided by the trademark office. They will be able to cite a maximum of 5 anteriorities, so no more than 5 senior trademarks will be able to base that opposition. The opposition will, as said, will be based exclusively on senior trademark rights. It's not possible to cite any further legal provision other than Article 124, item 19 of the Brazilian IP law, and to insert any text or any sort of arguments in this opposition modality. The main benefit that is aimed by the Trademark Office is to expedite the examination of oppositions in Brazil. So the goal of the Trademark Office for this year is to examine those pro forma oppositions in up to 21 months. Currently, the Trademark Office is taking a little more than 2 years to examine normal oppositions. So this will be an expedited modality for trademark users. I think one of the main reasons that led the Trademark Office to introduce this new form of opposition was the fact that, according to their statistics, more than 88% of granted oppositions in Brazil are based solely on Article 124, Item 19. So it's by far the most relevant legal basis for trademark oppositions in Brazil. There is an exception, which is if a normal opposition is also filed against that application, then the examination time will follow the ordinary term for a usual opposition. So this is also important. I mean, filing a pro forma opposition will not necessarily guarantee that the examination will take place on an expedited basis, because if a third party also files another ordinary opposition, then the case will follow that time frame. This pro forma opposition was not yet implemented by the Trademark Office. The expectation is that it will become available as of December 20th, 2025. So we still have some time to prepare for that. My personal view of this topic is that it's, of course, another positive innovation brought by the Trademark Office. It will be particularly useful for those parties that intend to oppose a trademark but are maybe negotiating an agreement or trying to force the other party to limit their list of goods or services. And while they are in those negotiations, they may just file a pro forma opposition, make the Trademark Office aware that they intend to proceed against that trademark. And if the agreement is later reached, they can just withdraw that simplified opposition. On the other hand, as you can see, the modality of this pro forma opposition is very restricted. So no arguments at all, no text at all may be inserted in the opposition form. And so I think this modality will be useful in very, very specific cases where the trademark owner is not really interested in convincing the Trademark Office about the conflict, but it just wants to file an opposition. Also for very blatant cases of entire reproduction, identity of products, this might be an interesting alternative in Brazil. Rafael, I think you're back. Can you hear me?
I'm back. Yes. Sorry. I think when I said I was surprised, something happened with my line. So I'm not surprised anymore.
Any comments on the pro forma opposition procedure?
I think you covered it all. I think it's a good opportunity for opposing parties to preserve their rights whenever they are negotiating, or when there's very specific and narrow point to be addressed to the office.